Hi, thanks for checking out Right Law Group's video page. Today I want to talk with you a little bit about the process of having charges for domestic violence leveled against you and what you can expect from that. Now this is going to be a very general overview of everything. We can get a little more in depth. What I'd like you to do is, if you're interested in any specific topic that we talk about in this video, just message me below or contact us at rightlawgroup.com so that I can provide you more information that will be helpful to you. But what I'm going to be talking about specifically is the process that Colorado Springs uses for domestic violence cases, because they vary depending on what jurisdiction you're in. And then if you have any other questions about other jurisdictions, we can get into that later. So, in Colorado Springs, what happens? The law specifically says that when there is an act of domestic violence and there is probable cause to believe that domestic violence has occurred, in order to protect the safety of the other people in the home and the alleged victim, law enforcement officers need to make arrests. Now, this is something that has been grossly overgeneralized, and I think a lot of law enforcement officers are confused on the law as well. What we have in Colorado is what's called a mandatory arrest law. So when there is an act of domestic violence committed, there is a mandatory arrest. However, this is where it gets tricky for law enforcement officers. The law does not state that you must make an arrest no matter what. If the police show up and they can't figure out who was the initial aggressor, or they can't figure out what actually happened, or they don't have enough to warrant probable cause to arrest someone, they don't have to arrest you. The problem is based on different political things going on and the policies of the different police departments, they'd rather be safe than sorry. So a lot of the times what we're seeing is people are getting arrested for DV charges when they shouldn't have been at all. That's notwithstanding the different defenses that people have, but just in general, there's a lot going on in these cases, and there's a lot of deeper issues happening that just can't be assessed in one 5-minute conversation on scene. With all that aside, in domestic violence cases, what normally happens is the cops will show up when a report is made. Generally, they'll talk to the reporting party first. Now, if the reporting party is the person who has been abused or is alleging abuse, then they'll talk with them, form an opinion, and then usually they'll act out an arrest on the other party. A lot of what we're seeing these days, though, is we're seeing other people call in. So people trying to be good Samaritans, people hearing things they'll call, and then you're in this situation where you have the cops called on you and your significant other, and neither of you called the cops. In the future, we're going to do a whole segment on that and what to do, but just so you know, this is happening and it is an issue that we need to address at some point in our legislature. For now, my point is to go through everything and give you an idea of what to expect. So let's say the cops show up and someone has alleged that you have committed an act of domestic violence. Now, domestic violence can range from anything to yelling at someone and shoving them away, to taking a phone away, even for a short amount of time, to blocking someone from leaving, to slapping them across the face. There's all kinds of things that constitute domestic violence, and not all of it is physical. The actual definition of what domestic violence is someone exercising power and control over another person in an intimate relationship setting. An intimate relationship doesn't even mean that you're having sex. It could be, I've seen domestic violence charges against young kids who are 13, 14 years old, and they're dating, but one of them is doing something where they're acting in a power control, domineering way over the other, and they get charged with domestic violence. So when you have a domestic violence charge, there are a couple of things to be aware of. Usually, if we're looking at like a misdemeanor domestic violence charge, you're still at that misdemeanor level, but having that additional DV tag makes it a much more serious case. And what I mean by tag is you can't be charged with just domestic violence in general. Domestic violence is an enhancer, something that they add on to an already existing criminal charge. For example, the charge of harassment. So if you slap someone across the face, that is harassment. It's a strike, shove, kick. If you are charged with harassment, and let's say you're at out at a bar having a drink with a buddy and you get real pissed off, and obviously I'm hoping you're not going around slapping your buddies on the face, but if you do something and you hit them, that can be harassment, so long as you don't actually cause serious pain to them. But if you slap them, that's harassment, not domestic violence. If you're in an argument with your significant other and you slap them, and it is a way that you are trying to control the situation or manipulate the situation, or you're acting out of anger towards them and you're doing it in a domineering way, that can be classified as domestic violence. Now again, this is very, very broad, And it's one of those areas where law enforcement just jumps immediately. If there are two people in a relationship, domestic violence is applied. That's something we're working on, and I can talk more in other videos about a nonprofit that I'm a part of that we're trying to change the narrative as far as what domestic violence is. That's a different topic. If you get arrested for domestic violence, here's what's going to happen. In Colorado, there is a provision that says that as soon as domestic violence is charged, a protection order, a mandatory protection order, goes into place. It's governed by the statute 18-1001. Now in Colorado Springs, what happens is you are prohibited, when you have this protection order entered against you, from having any contact with your significant other whatsoever, unless a judge lifts it. It's actually the same in Pueblo County as well as Arapahoe County and Douglas County, but specifically for El Paso County. What will happen is when you are arrested, you then have to be advised of the charges against you. Unfortunately, in domestic violence cases, you don't automatically get to bond out, because in Colorado, there's a provision of the Colorado Constitution called the Victims' Rights Act. Under that act, a victim or an alleged victim in a domestic violence case has the right to be heard on the issues in this case and has the right to be updated as far as what's going on. So the district attorneys are required to let the victim in the case know what the charges are and get their opinion on bond before you are allowed to be heard on bond. So what often happens is when you're arrested for domestic violence, you're sitting in jail for a couple of days. The worst time is if you're arrested, let's say on a Friday before a holiday, you're going to be stuck in there until at least Tuesday the next day if the holiday is on a Monday. And there's no way to get out. Because of the Victims' Rights Act and the way that it's put in place, the DAs must make contact with the victim first. Now, they may not be able to get a hold of them, and that's an entirely different talk we can have, but you are going to be sitting in custody until they do that. Then what happens here in El Paso County is you're brought into a specific holding cell in CJC, the jail here in Colorado Springs, and you're advised via television of the charges against you. There's going to be a judge or a magistrate sitting there. They're going to tell you what the charges are against you, and they're going to reiterate that you have this 18-1001 mandatory protection order issued against you, saying that you can't harass, molest, intimidate, retaliate against the named victim. And in this term, molest means in any way tamper with. Now, what happens in these cases is at that hearing, you will be given a bond. And generally what we're seeing on DV cases is it's going to range on a misdemeanor case. It's going to range anywhere from $1,000 to $2,000 all the way up to $5,000 or $6,000 depending on the severity of the charges against you. It's completely different for felony cases, and it can be a wide range in those cases. But with those, you're going to have the opportunity where the victim can speak if she wants in court, if she's there and present, and the DA is going to make a bunch of requests of the judge. At that time, your bond will be set, and then you can either bond out, or if you don't have the ability to, you'll remain in jail. The next thing that will happen is you'll be brought in for a PreTrial Conference. So if you bond out, you'll be given a piece of paper with a court date on it saying, this is your PreTrial Conference to come and talk to the district attorney. Now, what I strongly advise is between being released from jail and that pretrial conference, get an attorney as fast as possible. Because there are a lot of things going on, as you've probably figured out in this discussion. A lot of different things are happening, both policy-wise and criminally, that you need to kind of know the different nuances of these domestic violence charges, and you need an attorney who understands these things to help you navigate this in the best possible way. The reason I stress the importance of this is because if you have a charge for domestic violence on your record, you will be prohibited for the rest of your life from owning a firearm, even on a misdemeanor case. The reason this is important is because members of our military here, it completely negates your ability to do your job. You can't go to work because you can't have a firearm, you get kicked out of the military, and your life is over for a slap. That happens all the time. So I really want to stress the importance of really contacting an attorney as soon as you can if you're charged with domestic violence offenses. Now, at this pretrial conference, what will happen is the DA and the defense attorney, or if you go pro se, meaning you go on your own, you all will meet and discuss the case and determine what's appropriate. I'll make some more videos about the different options that we have in these cases. This is just kind of a general overview to give you an idea. But there are a couple different options that we have here in El Paso County that we can work with the DA, and there are a couple different avenues that you can take. In these cases, though, after the pretrial conference is set, they're going to ask you to enter either a plea of guilty or not guilty. If you're determined that you're going to enter a plea of guilty, they'll reset it for a sentencing where you'll go through the sentencing process. If you go with the not guilty track, that'll give you another court date where you will either have another pretrial conference or you'll start the process of going through pretrial readiness and trial. Now, again, this is something you'll have to discuss with your attorney, but it's very, very important that you make sure that you get everything together as quickly as possible and get that attorney hired and on your side, because these cases are much more serious than other misdemeanor cases. The other thing to be aware of is during this entire time, likely you're not going to be able to have contact with your significant other. Now, what that means is any kind of contact, phone calls, text messages. You also can't indirectly contact them through family members. The reason I stress this is because if it comes out that you have been trying to influence that other person in any way, or even that you've been contacting them, you can be charged with a new criminal offense. It's called a violation of a protection order. It's a class 1 misdemeanor. And then you just have this whole process starting over a second time. So a lot of the times we as defense attorneys can file motions on your behalf asking to have the protection order modified or lifted so that you and your significant other can have communication again, but it's not always granted by the judges. So you just need to be aware of what you're potentially looking at in these cases. It's very difficult on families for domestic violence charges because you're split, you're having to move out of the home. During your advisement, they'll give you the chance to get what's called a keep the peace order, meaning that for about 10 to 15 minutes you can run back to your house with police officers escorting you, get any belongings that you need, and then leave. And that's the last time you're able to go home. Because while this protection order is in place, you can't contact your significant other, you can't be at the home that they're at, anything like that. So this process is very convoluted, very difficult, and it's something where you really need to seek counsel immediately, if at all possible, just to help you through this process. My goal is to have some more information here for you shortly for different things that may come up. And if you have any questions or suggestions, things that you'd like to see in video, please let me know. You can leave us comments here below, or you can contact us on our Facebook page, or you can go to www.rightlawgroup.com and give us your information. But again, these domestic violence charges are very serious, they're very complicated and convoluted, so your best option is to hire an attorney as quickly as possible.